I call this meeting to order. Welcome to meeting number 29 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to Section 108, Sub 2, and the motion adopted on February 8th, the committee is meeting on a study of government obligations to the victims of crime. Today's meeting is taking place in hybrid format pursuant to House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to take a few moments for the benefits of the witnesses and the members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen for either English, French, or the floor. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed to the chair. I also use time cards. When you have 30 seconds remaining, I'll just flash the card. So try to pay attention to that because I don't want to interrupt. And if you're out of time, I'll put the out of time flash card. And then please just tidy up immediately. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raised hand function. The clerk and I will manage the speaking order as best as we can. And we appreciate your patience and understanding in this regard. Witnesses will have 5 minutes each before beginning a round of questions. I'd like to now welcome our first hour witnesses, Arlene Gaudreau, Monique St. Germain, and Kat Owens. So we'll begin with Arlene Gaudreau for 5 minutes.
Oui, bonjour.
Yes, hello. First of all, I would like to thank you for allowing me to participate in this consultation. I am the president of the Association Québécoise Plaidoyer Victimes. It's an organization that collectively defends victims' rights. I would like to begin by thanking you for the opportunity and we would like to acknowledge the work that's been done by the federal government to raise awareness of the Canadian Charter of Victims' Rights and to update its provisions in practice and to support the mission of many organizations that assist victims. Thanks to the financial support of the Department of Justice and the collaboration of the Ministère de la Justice de Québec, our organization has initiated and directed several large-scale projects to give victims better access to their rights and to better equip the workers who accompany them. In the time available to me, however, I will highlight some of the obstacles to the exercise of victims' rights and remedies in the criminal justice system and make some proposals. First of all, I would like to talk about the lack of awareness of the rights enshrined in the Canadian Charter of Victims' Rights. So the right to information has been widely documented in consultations across Canada and in reports by the Office of the Federal Ombudsman for Criminals of Crimes, and in particular, the Office of the Federal Ombudsman for Victims' Rights has recommended that information to enable victims to exercise their rights and remedies be provided proactively rather than on demand. This is an interesting proposal, but one that should be further explored in terms of its implementation. And one should look at the provisions of provincial and federal legislation that address confidentiality and privacy, to look at the mechanisms and resources that should be put in place to consult with a large range of victims to gather their views and concerns. The Charter provides some difficulties, and one of those is that it provides a brief and non-exhaustive list of rights that victims can exercise in different contexts and with different authorities. The rights are poorly defined, and the obligations of the various authorities and justice actors are not specified. So this, as a result, means that the victims have to take multiple steps to navigate the various procedures and to find answers to their questions. And to address these difficulties, several agencies have adopted policies, guidelines, and service statements that specify their roles and responsibilities with respect to victims and the measures that they can put in place to ensure that their needs and rights are better taken into account. I have two examples. There is the Directive 784 issued by the Commissioner of Corrections Canada, and those issued by the Director of Criminal and Penal Prosecutions in Quebec are initiatives in this direction, and they could inspire other organizations that have not yet defined their commitments. The Charter also presents a barrier with respect to the rights or discretionary rights in many cases, and the justice actors have a great deal of latitude to assess what is reasonable and to evaluate what is within the relevant of possibility. And the Charter also depends on resources available to certain organizations and their missions and their positioning towards victims. And there are also other other legislation that also affect victims' rights. And these realities are often not well accepted or understood by victims. When the Charter was adopted in 2015, the intention of the legislator was to provide remedies to victims when they considered that their rights had been violated. And so this was a step forward. But unfortunately, when we look at the results right now, we can see that it's very disappointing. At the federal level, with respect to the number of complaints, we can see that there are very few complaints with the federal organization. And that seems to mean that the victims are not aware of remedies available to them. With respect to provinces and territories, right now we don't have any means to really gauge what has been done to meet the requirements of the charts because we have no analysis and very little data. So we really do need to do a stock-taking exercise to examine what has been put in place by all organizations and departments across Canada. And we also need to identify problems that are faced by victims and to identify changes and remedies so that they can, and this must be done in close cooperation with all relevant bodies. The Ombudsman has made recommendations with respect to a proposal which we've often heard, which would be the possibility to have administrative or judicial remedy. Right now, that is not the case. So we believe that this is a very complex issue, and that it really a working group should study the feasibility of introducing this type of remedy in our criminal justice system in Canada, and to make recommendations so that we can move ahead with our thinking and with the actions that should be taken. Now, with respect to restitution and compensations for damages, judging from recent publications by the Department of Justice of Canada, the amendments made by Bill C-32 to improve enforcement of restitution.
Madam Gaudreau.
That's fine. So there are just two things that I would like to say. I think that we need to look at this issue of restitution, because not only have we not improved restitution and compensation for damages, but we've seen that there are less activities. So, as conclusion, we would like to say that we are disappointed, and we don't understand that the federal government has really not gone ahead with the parliamentary review that was to be done, and it was foreseen when the law was adopted. And this would be very important to be able to go ahead to my last sentence, so that we'd be able to see what are the best practices, and that we'd be able to have those in the working effort. Thank you very much for your work.
I have Monique St. Germain, General Counsel for the Canadian Centre of Child Protection, for 5 minutes.
Thank you, Mr. Chairperson and distinguished members of this committee. Thank you for the opportunity to participate in this study. My name is Monique St. Germain, and I'm General Counsel for the Canadian Centre for Child Protection, which is a global leader in combating the proliferation of child sexual abuse material on the internet. We are a national charity and we have been providing programs and services to victims of crime for over 37 years. For the last 20 years, we have operated cybertip.ca, Canada's national tip line, to report the online sexual abuse and exploitation of children. The tip line is a central part of the Government of Canada's national strategy for the protection of children from sexual exploitation on the internet. Our role through CyberTip is to triage reports to the appropriate police and child welfare agencies where necessary, raise awareness through education, and provide support services to assist Canadian families and children directly. The tip line has never been busier, and my goal here today is to be a voice for the victims and families we help. In 2015, our agency believed the Victims' Bill of Rights was a vital step towards a fairer system for victims. We still do. But since 2015, the extent of online child sexual exploitation has exploded. According to Statistics Canada, the overall rate of police-reported incidents of online sexual exploitation and abuse have increased from 50 incidents per 100,000 population in 2014 to 131 in 2020. These numbers signal we have a tremendous problem on our hands, especially considering the numbers would be the tip of the iceberg. Child sexual abuse crimes are grossly underreported. Many cases involve perpetrators who are a member of the child's immediate family or household, or a person known to the victim's family, making the need for supports for both the child and the non-offending family members critical. Yet many victim services programs do not cover services for the victim's family. Perpetrators of online crimes such as luring or sextortion may be committed by anyone, anywhere, and on any platform. There are jurisdictional and other complications that make investigations difficult, leaving many victims without justice. Today, reports of sextortion are through the roof. Multiple policing agencies, as well as cybertip.ca, have been issuing public alerts to try and warn parents and their children of the highly organized and ruthless nature of these crimes. If you don't work in this space, you don't know how bad it can get. Our agency has become connected with families of children who have died by suicide after being the victim of sextortion. We've worked with survivors of child sexual abuse material, who have essentially become secret public figures to those in the offending community. Their images are widely distributed, creating an ongoing cycle of abuse and an endless stream of offenders. Survivors responding to our International Survivors Survey told us that these crimes have a significant lifelong impact on them. The power of their stories led us to create Project Arachnid, an innovative global tool that can detect where this material is being made publicly available online and issue takedown notices. So far, over 6 million images and videos of child sexual exploitation have been removed from the internet following a Project Arachnid notice. These images and videos were detected across more than 1,000 electronic service providers spanning nearly 100 countries. The problem is immense. I will close with a few recommendations. I'm sorry. First, as a signatory to the UN Convention on the Rights of the Child, Canada agreed to take all appropriate measures to promote physical and psychological recovery and social reintegration of a child victim of any form of neglect, exploitation, or abuse. Online crime victims need ongoing safety planning, therapy, and financial support. Their non-offending caregivers need the same things. These services and supports must be consistent across provinces. Then there's restitution. Adding it as a specific right seemed like it would help. However, as an organization that closely monitors case law on all online child sexual exploitation offenses, we can tell you unequivocally that restitution is not being ordered or even considered in most cases. Is found in the collection of a subsequent offender. This means victims of child sexual abuse material are rarely recognized as victims, and so their rights under the Victims' Bill of Rights are not being fulfilled. In closing, we know there are families out there doing their own investigations to unmask and protect themselves from an anonymous online perpetrator. Victims who are self-policing to find their own content online to request its removal, and non-offending caregivers struggling to hold it all together while being told by systems that are supposed to help them that they are not victims. It is not right, and it is not sustainable. We urge the government to play a leadership role in better supporting victims of crime, not just through the criminal justice process, but beyond.
Thank you, Now we'll go on to Ms. Kat Owens of the Women's Legal Education and Action Fund for 5 minutes.
Thank you. Good morning, committee members. My name is Kat Owens, and I am a project director at the Women's Legal Education and Action Fund, or LEAF. I am grateful for the opportunity to appear before you today from Tkaronto, or Toronto, which is within the lands protected by the Dish with One Spoon Wampum Belt Covenant. LEAFs is in solidarity with Indigenous communities, and we echo their calls for, among other things, the immediate implementation of the Truth and Reconciliation Commission calls to action, as well as the calls for justice from the National Inquiry into Missing and Murdered Indigenous Women and Girls. This government has urgent obligations to bring justice to missing and murdered Indigenous women, girls, and Two-Spirit persons and their communities, and to ensure that not one more Indigenous woman, girl, or Two-Spirit person becomes victim to this crisis. LEAF is a national charitable organization that works towards ensuring that the law guarantees substantive equality for all women, girls, trans, and non-binary people. And it does this through litigation, law reform, and public legal education. LEAF is glad that this committee is not only studying the Victims' Bill of Rights, but is hearing about how victims or survivors of crime can be better supported generally. Given the nature of LEAF's work and expertise in advancing gender equality, I will focus on how to support survivors of gender-based violence, including sexual violence, of which women, girls, trans, and non-binary people are disproportionately the targets. As you know, gender-based violence takes a devastating toll on the lives of victims, survivors, and their loved ones. It disproportionately impacts women who are Black, Indigenous, queer, trans, or disabled. And we urge you as parliamentarians to hear from and listen to members of these communities and the organizations led by them as you do your work. We need survivor-centered approaches to addressing and ending gender-based violence. And survivors must have agency and choice in every step of the process. Too often, the criminal justice system is the site of further harm for those who look to engage with it. And for many survivors, especially those who are Black, Indigenous, trans, or criminalized, it can simply be unsafe to come forward and engage with formal legal systems. I have 3 non-exhaustive recommendations to provide this committee on how to better support survivors of gender-based violence. First, we need a fully funded, intersectional national action plan to end gender-based violence. Piecemeal changes to how systems deal with gender-based violence are insufficient to adequately address the problem. We need holistic solutions. We also need parliamentarians of all political stripes to ensure that this work moves forward in a timely way, that it is guided by expert organizations and those with lived experience, and that the plan is put into action. Second, it is imperative to study, develop, and implement survivor-centric alternatives that move beyond existing legal systems. Alternatives like restorative justice and transformative justice models broaden the possibilities for justice, accountability, and healing. LEAF is ready to support this work through its Alternative Justice Mechanisms project, which will look at legal barriers to these types of mechanisms for sexual violence and propose law reform measures to address these barriers. Third, we need to make changes to our existing legal responses to make them more accessible to those survivors who choose to engage with legal systems. Free, independent legal advice and representation must be made available to survivors of gender-based violence. This is crucial for them to understand their options and their legal rights and how to navigate the justice system. In the criminal context, we need to reform how publication bans are implemented and removed in sexual violence prosecutions, as well as how the criminal justice system deals with breaches of bans by survivors. Whether a publication ban is issued to protect a survivor's identity should be an informed choice made by that survivor. Should she no longer want the ban, there should be a simple process to remove it. Finally, a survivor should never be prosecuted for breaching a ban put in place solely to protect her identity. I understand that Morelle Andrews will be appearing before you on Thursday, and I would encourage you to listen to her lived experience, leadership, and expertise on this issue. And thank you for your time. I'll be happy to answer any questions that you have.
Thank you, Ms. Owens, for being on time. I want to welcome some members that are here substituting today, Ms. Taylor-Roy and also Monsieur Deschamps to the committee. I'll begin by having the first round of 6 minutes, beginning with Mr. Brock.
Thank you, Chair, and thank you, ladies, for your presentations and your willingness to participate in this extremely important study. I'd like to speak to Monique St. Germain initially. And my initial thoughts, Ms. St. Germain, is that your commentary alone with respect to the proliferation of child exploitation matters in Canada could easily form its own study. It's multifaceted, it's multi-layered, and I'm coming at my questions to you as a former justice participant who prosecuted these cases for the better part of 2 decades. And I share your frustrations and concerns with respect to the inadequacies that the current system has to ensure that we deal with the underreporting issues and that we deal with the supports that are currently lacking for all child victims across this country. So I listened very carefully to your recommendations, and one of your comments was that child rights, in your view, are not being fulfilled by the current drafting of the Victim Bill of Rights. Could you expand upon that for me, please? And I'll give you as much time as you need.
Yeah, so our organization has been working with victims of child sexual abuse material now for several years. And what we're hearing from them, bar none, is that their safety considerations are immense and that the long-term impact on their life once child sexual abuse material has been created is not well understood by any of the systems that are in place to support them. So for example, when they go to counseling, the counselor often doesn't know how to deal with the imagery piece of the victimization, because of course the imagery victimization is ongoing. So there's the initial abuse where the child is abused and the abuse is recorded, but then that recording continues to circulate online and continues to instill fear in the victim. And so their counseling needs are very different from counseling needs that may exist for other victims where the crime is in fact over. For these victims, their past is their present. So that is a big part of what we feel is lacking. Certainly across the board, we see that provincial systems are not equipped. The services that are being made available do not have the funding in place that will provide the level of therapy and counseling that these survivors actually need.
A general question now to Madame Goudreau and to Ms. Owens. One of the reflections I had leaving law and entering politics was the frustration that survivors of sexual violence have with the criminal justice system. They view it as a completely unbalanced justice system, that all the rights, all the privileges, all of the attention goes to the offender, and lip service, I'll use that, those are my words, lip service goes to the victims, which creates a level of distrust coming into the system, which probably explains why historically victims of sexual violence traditionally do not want to report it, because they know that it's really dependent on the quality of the police service who investigates, the quality of the local supports available to that victim, the quality of the prosecution, and the uncertainty of your judge. So with that in mind, I want to hear from both of you as to some of the shortcomings that the current reiteration of the Canadian Bill of Rights has in ways that we can improve, increasing the trust, increasing the reporting, particularly in the area of sexual violence. Either of you.
Yes, I'll start. Well, the Charter, with its writing, it's very impressive, and there are many rights that really are in the responsibility of the provinces. So it's difficult to have a charter that is really complete unless you mention all of the rights in all provinces. So to avoid this problem, the victims need to be able to have information in different forms, and victims need to be communicated with, contacted. So there are services for available so that questions and concerns can be responded to. The information is very general. There's a lot of information, but it's very general. So if people want to speak about their situation and to get specific responses, well, the justice system, it's very complex, and victims have to deal with different authorities. It depends whether it's what type of violence they've been victimized by. But I think that things that have moved ahead with in the justice system, Madame Owen has spoke about legal counsel, and there are more legal clinics that give information and advice, so there is some representation. So I think that there are many initiatives that have been set up, and the preparation of witnesses, for example, and the system is often criticized, but we don't really speak often of things that have moved forward. So I think we also need to have a positive message and give that positive message to victims. But it's a very, very labor-heavy experience to deal with the legal system.
Brock. Next we have Ms. Diab for 6 minutes.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair. I would like to start by thanking all of our witnesses today.
Giving a brief opportunity to each of the three of you, although our time is limited, to give me your comments with respect to the new appointment of the new ombudsperson for the victims how do you see that in each of your categories? I know Leaf spoke about the great work that you're doing on gender-based violence for women and in the intersectionality. And I know Miss Monique Germain, you spoke about the online sexual exploitation and the child sex abuse on the internet, which actually is something that I was quite familiar with as a Nova Scotia person back when we implemented the Cyber Safety Security Act in our province. But I'd like to know how you think the ombudsperson could aid with that, if at all. So, Ms. Owens, I'll ask you first.
Thank you very much for the question. I think it is always important to have more information as opposed to less, and to have a sense of how our systems are working and not working for survivors. And I think that having an ombudsperson who is able to do that sort of work in assessing the systems is very important. I would just go back to the point that whatever approaches are taken to respond to violence, they need to be survivor-centered. We need to ensure that survivors are informed about their options, that they have agency and that they have choice, and that we expand those options. And I do think that the ombudsman's work, or the ombudsperson's work, could be very supportive of that. So thank you for the question.
Okay. Thank you. Madame Saint-Germain?
Yes, I would echo what Ms. Owens has said, and to build on that, the work of the Ombudsman from the perspective of online abuse and technological abuse could perhaps play a role in educating the various actors within the system of specific types of trauma and other safety planning considerations that need to be put into place, particularly when we're talking about children. One thing that we see as an organization is that victims of child sexual abuse material, as an example, the offenders know who they are, or they spend time trying to figure out who they are. So there are safety considerations that need to be taken into account a little bit differently because that imagery is living online. The ombudsperson could be very effective, I think, in terms of educating and pulling together information from various jurisdictions to help better inform all actors within the system of these types of challenges.
Madame Gaudreau, s'il vous plaît.
Madame Gaudreau, would you like to make a comment? Well, the Ombudsman's work is important also to analyze the systemic issues and the main issues that smaller organizations sometimes don't have the time or the resource to analyze. So I think that the report public that was put out by the Ombudsman was very important, and it's really gives a voice for victims of crime in Canada so they can analyze the issues and help move ahead to the rights of victims. So I really am very pleased that he was nominated.
To you, Ms. Owens, you spoke of the holistic solution, and I invited all parliamentarians, regardless of party affiliation, to work together for gender-based violence is a common out there. We all know that, particularly with women and Black, Indigenous, queer, disabled. I'm wondering, how about multicultural as women, people of different ethnic backgrounds, and so on? What would you say about that? Have you any studies on that? Have you looked at that? Or people women that are immigrants, new to the country, or that perhaps have been here for a long time but simply come from different backgrounds?
Yeah, I think one of the things that we see is that gender-based violence touches members of all communities, regardless of how new one is to Canada or how long one has been here. I think that it's important to keep in mind that how different systems of oppression work within this country influence the likelihood that a person may experience gender-based violence, as well as their responses to it and the services that are available to them. One thing I'll say that definitely speaks to the experiences of folks who are new to the country, and also when we're talking about Black and Indigenous folks in particular, is the way that the current default police or carceral response to gender-based violence often does not work. These may not be institutions that they feel they can engage with. And so there is a need to broaden options and responses available to these community members especially.
Thank you, Mr. Chair, and thank you to all of you.
Thank you, Ms. Diab. Next to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you to all of the witnesses who are here today. It's a real privilege to be able to count on all of your knowledge. My first question would be for Madame Gaudreau. Madame Gaudreau, I understand from your testimony and also from other witnesses that we heard on this issue, it seems that there is a major problem with respect to the information that's put out. You've said it, others have said it, but I would like you to speak to this issue. What can we do to ensure that victims of crime can be better informed about their rights? You talked about restitution earlier, and you were talking about, I think if you had any more to say, your time was up, but if you have any more to say on that, that would be great. So first information, and then the question of restitution for harm from the crime that they were victims of. Well, I think that we need to continue to produce written information in other forms, as I was saying earlier, But I think also that all of the people working in the field need to be well trained, and that's important. So they need to have a rigorous approach with all of the information, that it be updated and that they're aware of all of the legislation and practices. And so we also need to be able to ensure that victims access the right resources. Sometimes they may need legal advice, or it may be procedural advice. So there are different organizations that are specialized in one area or another. So it's very important for the public generally, but for victims especially, to be aware of this. So all of the people working in the field need to be aware. So during the pandemic, there was a lot of turnover of staffing, and there's a lot of new people in. So within the law faculties, there'd have to be a lot of training given with respect to informing victims. So with respect to restitution, what I believe is that in provinces where there are mechanisms in place where people are devoted. So, for example, if there's an organization for services for victims that takes care of informing the victims and that helps them. And so when there are programs in place, it's much easier to give support to the victims rather than when they're left on their own. So it's terrible to see that within the Charter, there's a 17% drop in restitution amounts. So this means that victims are not being informed, and that the procedures are too heavy for them to be able to apply, especially when there's a non-payment of restitution. It's much heavier. It adds burden for them. So I think that we really do need to look at what works well and what are the best practices in other provinces, so that they can be used and help inspire other provinces to do as well. The federal government there's a $38 million of funding that was spent to different services and different projects. So we need all of us, all across Canada, to be able to analyze the results and to look at all of these programs so that we can share them. So I think that is a role that the federal government could be greatly involved in. Thank you very much. You're talking about informing lawyers who are studying law, future lawyers studying law, but also sometimes you're saying the victims aren't necessarily well informed. So would it not be a good idea to have certain provisions within the criminal code so that victims may be really involved, be party to proceedings, so that they're able to be a part of involved, especially when it comes to plea bargaining, and when you have sometimes I think it's important that there be negotiation with respect to sentencing. That couldn't be something that often the victims are not really informed about. So given all of that, would it not be a good idea to see that judges themselves be better informed on the rights of victims, and that the victims are able to participate in all of the proceedings of the justice system? Is the question for me? Yes, Madame Goudreau. Well, the victims are witnesses, and they're on the periphery of the justice system. So how for things to evolve well, the victims need to be aware of the Charter, and they have to be aware of remedies, whether it's before the courts or whether it's an administrative tribunal. But I think that things are starting to change. I think it's important to consult with the victims, to ask them what their concerns are at the different steps through the justice system. And that is the police services and other authorities, those that people working in the administrative tribunals and all of the people working in the justice system have to be able to be aware and have more of a role to play. So victims can give an opinion on a decision. It's very rare that they're asked to be given their feelings on it. So this is something that needs to be looked at. But we can't really totally change the system.
6 minutes.
Thank you very much, Mr. Chair, and I want to thank the witnesses for being here today, and I apologize in advance if my lingering COVID systems overtake my questions at some point here today. We have heard quite a few witnesses now talking about the differences in approaches and support levels and all kinds of other programmatic matters between provinces. And we've also heard, in particular in our last session, about the existence of clear best practices and minimum standards in other jurisdictions. So my question would be to Ms. Gaudreau to start with. Do you think that something like a national task force with federal, provincial government representatives and victims representatives could usefully establish best practices across the country and minimum standards?
Ce serait une bonne idée.
Well, I think it would be a good idea. 10 years or more, there was a policy center for victims where reflection and exchange, very interesting exchange all across Canada occurred, and that's something that's missing, to be able to share with representatives of other provinces and territory with respect to all of the work that's being done with respect to barriers. So I do think we need to look at standards and maybe to look maybe at the UK charter, which is based on commitments with respect to the victims. So this is something that is promising, and I think that could be really a good possibility, a good idea.
As members of the Justice Committee, I think we're often focused exclusively on the legislative solutions or legislative problems, but clearly what witnesses are telling us that it goes far beyond simply fixing the legislation. There's much more that needs to be done. So I would ask the same question to Ms. Owens about whether it would be useful to have some kind of national task force working on establishing best practices and minimum standards for assistance to victims.
Thank you for that question. I do think it goes back to the point that I had raised earlier with respect to the National Action Plan to End Gender-Based Violence. I think thinking about minimum standards and how we respond to victims and survivors in a consistent and appropriate manner across the country is something that might fall quite well within the framework of what's being spoken of there. And I think it does also speak to the need to look systemically as opposed to at piecemeal portions of the system. So I would certainly think that looking at how that fits within that framework and in moving that framework forward is something definitely to be explored.
Thanks very much. In previous submissions by LEAF, especially on the question of coercive and controlling behavior, and again today you talked about unintended consequences of changes in the legal system. And so we've had many people suggesting that there needs to be a provision for automatic informing of victims of their rights and of programs. Would you have some comment on possible unintended consequences or concerns that LEAF might have with that automatic information system proposal?
Yeah, I think it would be something where, and other witnesses have shared this, it would be very important to consult with survivors and victims to get a sense of where they're coming from. I think the challenge with anything that is automatic is that all survivors and victims will have different needs. And so a one-size-fits-all approach can just be challenging for meeting the needs of survivors. I appreciate the administrative clarity that it provides, but it is certainly challenging to meet individual needs when you're taking on one approach for all survivors.
And maybe I would go back to Madame Goudreau on the same question, because you mentioned at the beginning of your presentation, Madame Goudreau, that many people lack the basic information of what their rights actually are, what the possibilities are. So could I get your response and your organization's response to the idea of some kind of mandatory information provision to victims of crime?
Well, I agree with Madame Owen. I don't think that it necessarily responds to the needs of all of the victims. They follow procedures, and some don't follow everything. Some find it too heavy. They're not psychologically apt to be able to follow things. Some victims are there for the sentences and they just want to move ahead, or they want to move ahead. So there are many different types of needs. So to impose automatic information to everyone, I don't necessarily think that it's really the best option. I do think that it's important that that a broader consultation happen with different categories of victims to see what are their needs. And there's a question of resources too. If we have a system that's able to do that type of work, well, it's going to take financing and a lot of resources. And a lot of the information is done through provinces, and so they'll have to be involved too.
Thank you very much. One last quick question, maybe to all three of you. There's been a lot of concern about the under-resourcing of the Office of the Ombudsman for Victims of Crime. Do you have any comment, maybe starting with you again, Madame Goudreau, on the relative resourcing of the office compared to other similar ombuds offices?
Very brief answer, please.
Well, the Ombudsman's office doesn't have a lot of staff if you compare with other areas in the correctional system. So I think that would be important for them to be able to fulfill their mandate and to be able to reach everyone. So I do think we'd also have to look at the linguistic issues too, so that there's sufficient amount of staff that speak the two official languages, so that francophones that go to the Ombudsman's office may be able to have access rather quickly to somebody who speaks French.
Next, we go to Mr. Richards for 5 minutes.
Good, thank you. In the meetings we've had on this topic, every time I'm struck by usually several things that we hear from those of you who come to speak with us. Just things that you just shake your head and you say, like, how can the justice system put victims and their needs and their rights in such disregard? And certainly today was no exception to that. There was a couple things I wanted to just follow up on a little bit, and one of them was Ms. St. Germain. You mentioned about restitution and how it's often not being ordered and certainly not being enforced, and I wanted to touch on that a little bit. We'll do that first. I also just wanted to mention, Ms. Owens, I do want to ask you a little bit more about, you talked about the publication orders and what's sort of happening to some victims in terms of breaches of bans there. I wanted to follow up on that a little bit more too, but we'll start with you, Ms. St. Germain, and maybe just talk a little bit more about the restitution orders. Maybe give some sense as to sort of if you've got stats that sort of tell us how rarely that's happening, how often it's happening, why they're not being enforced, and if you have suggestions on what could be done to improve that, we'd love to hear those as well.
Okay, well, I don't have any stats as it connects to the restitution issue. What I do know is that our organization monitors reported case law So all the decisions that are publicly available to lawyers regarding sentencing and other matters that are going before the courts. Restitution is almost never mentioned in the offenses that we monitor, which are the online child sexual exploitation offenses, like what is called child pornography in the criminal code, online luring, agreement or arrangement, those types of offenses that tend to involve technology. The few cases that we are aware of where restitution was requested, it wasn't granted because the judge's sense was that the individual was going to jail for a long time, and so, he wouldn't be able to pay, similar to the reasons that judges use for not imposing a victim surcharge. So to that, our organization would say, people in this country don't go to jail forever. They do come out, they do get jobs, and they do work. And there's no reason why there couldn't be a restitution order that is there and that is payable at some point in their lifetime. It doesn't have to be obviously the moment they're incarcerated. The other issue that I think we have is with the wording of the criminal code itself, which requires that the restitution be readily ascertainable at the time of sentencing. For victims of online crimes, the damage and the full cost and impact on the person's life is often not even remotely known at the time of sentencing, because you don't know whether that person's child sexual abuse material is going to have gone viral within the offender community circles. You don't know what other offenders are going to target this person because their imagery is online or because their personal information was placed online. So those are some of the challenges that we see with the restitution issue.
Great, thank you very much, and I certainly hope the committee will make those recommendations, and the government will take up on those, because I think they're very wise recommendations, and I think will mean a lot to victims. Ms. Owens, I don't imagine we have a lot of time, but I'll turn to you what we do have, and if you do get cut off for whatever reason, maybe send in something in writing to the committee so that we can benefit from your recommendations in this area. But just in regards to the breaches of publication orders and sort of seeing victims being prosecuted for those, can you maybe just give us a bit more sense as to what you've seen happening here? What the result is for victims, and what could be done to improve that process and give victims the right to make a choice that best suits them in these scenarios.
Certainly, and I would commend the committee to Morel Andrews, who will be appearing on Thursday, who is really a leader and an expert in this area. I would just note that the most important thing for moving forward is for survivors to be able to have meaningful choice in terms of whether or not a publication ban is implemented and when one is removed. The ban is put in place to protect their identity, and that is what matters. And I see I'm out of time. Thank you.
Sorry, and if just on a very quick, maybe just to ask Ms. Owens if she could, I know you didn't have much time there, if you would like to present in writing how that might look in terms of providing choice to victims. Thanks for indulging me on that, Chair, but if you could send it in writing, that'd be appreciated.
Thank you, Mr. Richards. Next, we go to Ms. Dillon for 5 minutes.
Merci, Monsieur le Président. Merci.
Thank you, Mr. Chair. Thank you to the witnesses for being here. My first question is for Madame Gaudreault. You mentioned during your testimony that collaboration between provinces and territories was important. So what type of collaboration did you imagine? Well, exchange of data, more data. So that would be, well, first of all, we need to collect data. And there should be more exchange of data between the federal and the provinces. And since the adoption of the Charter, we really haven't seen a portrait of what exactly has been happening in the provinces and territories. So we don't really know what's working, what's not working, what are the best practices. So I think maybe there should be a special committee with the federal government and involving provinces and territories to have an ongoing examination of the different barriers that victims are faced with. And things happen in silos, really. You can see it with financing. Some programs are already financed by the provinces and they're also financed by the federal. So really there's a lack of exchange so that everybody knows what's being done, what we're doing in the field, so that we'll all be able to move forward and advance, and that we improve the rights, that we share research more readily. That's the type of work that needs to happen. I think that things are too much in silos and everybody works in their own.
An example.
Do you have an example of programs that maybe are also overlapping with what's happening in provinces? Well, there are a lot of programs that are really for training for people working. So there's been a lot of federal money, and there's also money in the provinces. So this is important that training happens. So there's a general type of and targeted, both general and targeted training. And so what's being financed federally shouldn't be financed. The same things shouldn't be happening with funding provincially. There are a lot of legal clinics. We're seeing those happening. And we're seeing that there's a lot of different ways of working. Sometimes students are in criminology, or they're in studying law, and they're involved. They're supervised by professors, but there's sometimes practices that could be questionable, that may be both federally or provincially funded. So I think it's important to look at what's being financed, what type of activities, and what are the things we're missing. What are the problems that aren't being documented? Right now we're working on a project that would recognize and improve the rights of people who want to make a victim's declaration. And sometimes those people don't have information, and there's not really a mechanism in place so that they can consult with organizations. So there's a lot of work that needs to happen there. So sometimes you really do need to examine what's happening and to really assess the situation. But there's a lot of good things happening, and there's a lot of good legal counsel, but I think that what's missing is really the representation of victims in certain courts. So we have to look at the implementation of the charter, and we need to be able to move ahead with that analysis. And the provinces and territories who are responsible for the implementation of many rights, they're also very active. So I think we really need to know what's happening, and that we share all of what we've done. And the charter really can be an important tool to help with the victims' rights. And there are certain populations that aren't being communicated with, whether it's because of the remoteness, geography, or language. But it's not normal that in 2022 there are some young lawyers that are saying, well, I don't really know much about the Charter of Victims' Rights. I don't think that's acceptable in 2022. There's a lot of work that still needs to be done. Thank you, Madame Gaudreault. I would like to ask more questions, but I'm afraid I don't have any more time.
Thank you, Madame Dillon. Now we'll go on to Monsieur Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I would like to almost say sorry to Madame Saint-Germain and Madame Owens that I haven't asked many questions, but I do have a question once more for Madame Gaudreault. And so if the other witnesses want to jump in, it would be welcome. So, Madame Gaudreault, I'd like to ask you about something else. The question of collateral victims, for example, the children of a victim. And just as the children of the criminal, the aggressor. So if there's a young child and their father was found guilty they can also be very affected. There can be a lot of harm. So does the Charter really look at this type of thing to ensure that children or the spouses that are not involved either as a victim or as an aggressor, but they still are affected and have consequences? Well, that's a huge question. You're really noting that that's an important problem, and it's important, and it's true that you can't not be affected by the situation for these children or by spouses. But I think that there are programs to help these people, and those programs can be linked or depend on the correctional services to be able to assist those people. But that they be included as victims within the charter, we don't see that in other types of declarations or in other countries. But so I think we'd have to really think about it. But I think from what I know, I think that there are initiatives and programs that do exist, and more could. But this doesn't really correspond to the definition of victim. I think we'd have to really have an in-depth discussion of what it means. But maybe there are other solutions, and maybe it doesn't have to go through the charter. I don't have much time, Madame Gaudreau. I have another question.
Out of time.
Already?
Yes, it's 2.5 minutes, sorry. Next, we'll go to Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. I want to return to the question of relative resourcing of the various ombudsman's offices and give a chance to Ms. St. Germain first, and then Ms. Owens to comment on that question of relative resourcing of the ombudsman's offices in the justice system. So.
Thank you. In terms of resourcing, I mean, I think that it's known to everyone that there are tremendous challenges in resourcing across the entire justice system. The level of funding, though, that is tied to the federal ombudsman does need to be increased in order for them to have the role that they should be playing in our communities and in our society.
And Ms. Owens?
I would echo that, and I would also say that the ombudsman is obviously a key part of the response to ensuring that victims and survivors' rights are respected. But in the gender-based violence context, so too are a lot of frontline service providers, and LEAF has called for sustained core funding for these organizations, and would echo that call here today as well.
You've anticipated my next question and already answered it to you. But I think we all acknowledge here that we're in a peculiar situation where we ask the victims of crime to finance their own organizations and to finance many of their own programs for recovery rather than the public assuming that responsibility. And I know that that's the case in gender-based violence, but perhaps, Ms. Owens, you have more to say on that topic.
I would just say that I think that there has been significant funding provided lately, which is very much appreciated and has allowed for increased capacity building in the sector. But I do think that sustained core funding not tied to individual projects is something that will allow organizations to provide more effective and accessible services to survivors across the country. So thank you for the question.
And lastly, very quickly to Madame Gaudreau at the same point about funding for these organizations.
I would have an idea that the federal government could look at up until 1992, they supported programs in Canada. And I think that it would be a good idea to be able to do that again, and that would allow that would give the capacity to respond to the needs for support that many victims are experiencing, and I think that would help the provinces to be able to better accomplish their mandate.
Gaudreau. Thank you, Mr. Garrison. That concludes our first round. We'll probably suspend just for a couple minutes to do sound checks for our next witness and then resume. And for those in the room, coffee has arrived and there are some snacks for you guys. So I apologize for the delay in coffee, and hopefully you guys will stay sharp and awake for the next round. Take care. All right, resuming the second round, and we have one witness, Brenda Davis, an independent, and she will have 5 minutes to make her opening statements, and then we'll go for a round of questionings beginning right after. So the floor is yours, Ms. Davis.
Good afternoon. Thanks everyone for the invitation to speak today. On behalf of myself, my family, and all victims of crime, wanting changes to help us better navigate the criminal justice system. In 1987, my 16-year-old sister was murdered while she worked at my father's corner store by Patrice Mayou, who at the time was on parole and living in a halfway house nearby. He was convicted of second-degree murder and sentenced to life with no parole for 20 years. A number of years later, he was again, while incarcerated at a maximum security prison in Edmonton, given another 20-year sentence for a violent escape attempt, where a prison guard was injured. Since that time, he has continued to commit many crimes while incarcerated, as well as breaking parole conditions numerous times. Since that time, my family has had to endure numerous hurdles to have our rights as victims respected. We did not choose to be victims, but the offender did willingly choose to murder my sister. In 2007, we had to fight to receive translation services as the offender chose to have his parole hearing in French. As English-speaking victims, we deserve to be treated fairly and with respect as we fought to ensure justice was served. In 2009, just as my family and I, including my aging parents, had just arrived in Montreal to attend a parole hearing, when we were told the offender had decided to withdraw his request for the hearing, and it was immediately canceled, and we had to return back to New Brunswick. No reasons were given at the time for the cancellation. In 2020, amidst the pandemic, there was yet another parole hearing scheduled, but we were informed that the only way we could take part was by teleconference, even though the offender was able to have video conference with the parole board for the hearing. The same rights should have been afforded to us as victims. These are just a few of the struggles we have faced as victims since my sister was murdered almost 35 years ago. On September 1st, I was notified by the Montreal office of the Victim Service for Corrections Canada that there was a Canada-wide warrant issued for Patrice Mayou for breach of parole conditions, that he had gone unlawfully at large before they could execute the warrant. When asked when his last known check-in was, as he's on day parole, we were told that they didn't have that information. And we also asked what the breach of conditions were, and we were again told that they did not have that information, and if they did, it was confidential. And that it was now a police matter, and that victim services or the police would contact me if or when he was apprehended. I contacted the RCMP, my member of parliament, my local constituent, to voice my concerns for my family's safety and the safety of the general public, as this offender is an habitual violent offender. And even though he had had a Canada-wide warrant for his arrest, there was no publication that I could find anywhere. I was informed that the police were aware and that there were places they would look for him, or if they were to stop him on the road, then they would know he had a warrant. The RCMP provided more updates and assurances to me and my family than victim services did. I myself used the offender's most current photo from the victim's portal and released it via Facebook with his conviction, warrant info, and last known whereabouts, and asked people to share it far and wide. I was then contacted by corrections and told to remove the photo because it was confidential, which I did, but it had already been shared by hundreds. I also contacted a reporter with the local paper, a lawyer, CBC, and CTV News to tell them the story. They didn't post the offender's photo until they had spoke with a legal expert. Upon apprehension, the RCMP did let me know that they did receive many tips on his whereabouts from the photo that was shared through social media and the news. victims should not feel responsible for needing to protect themselves and the public. Another way victims feel re-victimized is when our victim impact statements are only allowed to be addressed to the parole board and are shared with the offender prior to the hearing. Victims should be able to speak directly to the parole board members as well as the offender, and the statements should not be shared with the offender prior to the hearing. The offender often uses these statements to prepare his responses at the hearings, which also include the offender giving false answers, to which the board members may have no idea are untrue, and we as victims are not able to question the offender when he makes false statements. These false answers may sway the board into a decision not based on true facts. When a violent offender is granted any form of parole, they should be required to wear an ankle monitor, so their whereabouts are always known, which will help determine whether or not the offender is adhering to the terms of their parole. Parole board hearings should also return to in-person, which are important as victims should be afforded the right to take part and observe the hearing. Being able to see the offender and the board as the hearing is conducted is a vital step in ensuring that justice is being done correctly. If the offender chooses to withdraw their opportunity to a parole hearing within 2 weeks of the scheduled date, it should be required that the hearing go ahead as scheduled and victims be allowed to attend, even if the offender chooses not to. Victims should not have...
Ms. Davis, if you could wrap up. You're a little over time, but hopefully we'll be able to flesh out the rest of your statement from questions.
Okay, thank you.
Okay, if you're done, we'll go over to Mr. Moore for 6 minutes.
Okay, thank you, Chair, and thank you, Brenda, for being here today. And I want to say at the outset, no family in Canada should have to go through what you've gone through. And having known your father, Ron, from his time as a councillor for the town of Riverview, he was always an impassioned advocate for not just your family in the memory of your sister, but also for all victims. And his words did have an impact when it comes to parole hearings, particularly around the issue that you mentioned of offenders canceling a parole hearing without notice to families. I know I recall him telling the story of when he traveled to Quebec for the hearing and then it was canceled at the last minute. That should never be allowed to happen. But your case, more than many, illustrates the re-victimization of the process. Your family and your sister were already victims of a criminal act, but then the process continues, unfortunately, and this is what we need to stop. It continues to re-victimize. And maybe you were in the middle of a thought, so if you want to wrap up your thought, but also if you can comment on the parole system, the frequency of parole hearings, the fact that the fact of the matter is the person that took the life of your sister was on parole when they did it. And then, in spite of that, Corrections Canada didn't know where he was as recently as a few weeks ago. And you spoke to me about how that caused fear for you as a family member. So if you can speak to how the parole system has to be improved, maybe some ideas you have that could make it better for victims' families, and the importance of victims' families always being looped in when it comes to actions of offenders.
Well, first of all, when someone's been put on parole that many times and continues to have his paroles revoked, breaks the rules, goes back to prison, commits more crimes, they put him back on day parole. He's been in the system for so long that he knows what to say to get his parole. And then he goes out and he breaks the conditions of his parole. And it's happened so many times. So we're constantly going to these hearings and having to fight to keep him in there because we know he's just going to do something again. And he was just gone for 3 weeks. He may be older. He's very capable. He's an able-bodied man. And if you run into something like he needed money, it's not hard for him to go and repeat what he's already done. He's never showed remorse, and we don't get told what's gone on until months after the incident. And now they've informed us just last week that the parole officer will be the one to decide if he goes back to day parole with extra conditions on him. And if the parole officer chooses to continue the suspension, then it will go to the parole board to make the final decision. But we don't get a say in that. It's not going to be another hearing. It's just they're going to make the decision and the family's left out. And we don't get told anything.
Thank you, Brenda. It's actually incredible to even hear this, that this person who should have never been paroled in the first place, in my opinion, and having had all these violations, it would even be considered to allow them some type of release. Do you think for families where it is a first-degree murder or second-degree murder, do you think parole hearings of 2 years are too frequent? Do you think if someone is denied parole, there should maybe be a longer period so that I've heard from other families and your own about you just finish one parole hearing and then you're already kind of anticipating in your calendar the next parole hearing. Would it help families if, having been denied parole, the next hearing was further out?
I think at least 5 years would be a good time in between. If they're denied for a reason. So I think, like you say, 2 years, people said that's not enough. It's not. You get over the hearing and then you start preparing yourself for the next one, because you learn a lot of stuff in those hearings. You learn of things the offender's done that have taken away privileges, etc. But we only find out about those things when we go to the parole hearings. So we're finding out about that, and then we're trying to compile all that information and find out stuff. And then all of a sudden it's time for the next hearing.
Thank you, Brenda. And other individuals are going to question you from the committee, but really appreciate you taking the time to speak to our Justice Committee, and I hope that your testimony has an impact on everyone on ways that we can improve the system for your family and others. But thanks again for taking the time to meet with us today.
Thank you.
Thank you, Mr. Moore. And next to Ms. Dillon for 6 minutes.
Thank you, Mr. Chair, and I thank Mrs. Davis for coming in and testifying about this very, very painful tragedy that her and her family have experienced. There are no words to express hearing the pain in your voice still 35 years later. I wanted to ask you if you could please tell the committee, in the last 35 years, you've been navigating the system, the criminal justice system. Have you seen any improvements when it comes to victims' rights or for their families? Because you are speaking for the victim right now, who was your sister. If you could please tell us a little bit, have you seen any improvements? What would you like to see improved even further? And just your experiences, please. Thank you.
Transparency for one. The families should be told exactly what these breach of conditions are when the offender breaches a condition or he's in prison and does something that ends him up in isolation or suspends his parole. We should be told what it is, and we're not told. We're not told till months later. Even then, there's things we aren't told. And I think as victims, we deserve to know that. No, it maybe doesn't have to do with the original crime, but he's in there serving time for the original crime. So I believe all of that adds on to it, and it's our right to know. And we're constantly told later, like our trip to Montreal that was canceled. It was months later before we found out why it was canceled. And it's just been continuous. Like, there needs to be transparency. We need to be, like as in our case, when he escaped custody and was gone for 3 weeks, we again did not get any answers. They said his warrant was issued on September 1st, which was a Thursday, but he does a 5 and 2 day parole. So he spends 5 days on his own and 2 days in a halfway house. So we don't actually know when he was last seen. They couldn't tell me where he was, where they thought he might be. And like, it's not fair to the families. And I was questioned, well, why do you think that you're in harm's way? Well, I think anyone can see that we've managed to keep him in prison for an extra long time after his parole was due. And that's because of his offenses. So I think we should be told exactly what's going on when it happens. And I think victim services should take more of a part in helping the victims. I had the RCMP call me 2 and 3 times a week to check on us, make sure we are okay. But I was also told that I should install a security system with cameras at my house. To me, that's not my job to do that. It's their job, corrections, parole board, to keep an eye on him, make sure they know where he is so that the victims don't have to worry all the time. And we shouldn't be the ones that have to go and put it out to the public. He's a high risk offender. He's a violent offender. He's been in jail since the 70s, almost continuously. And when he's been out, it's been parole. His parole's been revoked. And we're not getting answers. We only find stuff out later. We get to the parole hearings and he already has all of our statements. So he knows what to say. It's not fair to the victims. What we say should not be given to him in prior to.
So I'm so sorry we are so limited on time, but you spoke also about publication bans. Can you talk to us a little bit about how they're good for maintaining the privacy and dignity of victims, of complainants, but how they can also have unintended consequences?
I suppose it depends on the crime, whether or not something should be publicized. But in this case, I believe it should have been put out to the public immediately, and it wasn't. That's why I put it out. I put it out to protect people, and so that people knew if they seen him to call the police. But in some cases, maybe it shouldn't be put out to protect a victim. But in our case, he's a violent offender. He wasn't a sexual offender. And his victim didn't live. So we weren't protecting her. We just wanted him found to protect ourselves and protect the public.
I thank you so much.
Thank you, Ms. Dillon. Next to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Hello, Madam Davis. Thank you very much for being with us today. I'm listening to your testimony, and it's really troubling. It's true. It makes no sense what you've had to go through. The way of proceeding is crazy. The fact that you weren't able to be warned that there was cancellation. I think that should have been able to, that could be easily changed. I think victims should be able to be party to the proceedings, and they should be warned at least beforehand so that you don't travel for no reason. And another thing that I would like to discuss with you. Oh, I'm getting feedback, Mr. Chair. I wanted to discuss with you the question of language. I understand that you had some trouble. I wasn't really clear, but the trial was requested to be in French. I can understand that since I myself am a francophone, and so I can understand that he asked to have a hearing in French, but I don't think it should be to the detriment of the victims. But so I would like to ask you, how exactly did that happen? What I understood was that you were not aware that there was no interpretation services available. Could you please tell us a little bit more about that situation?
Originally, for the first hearing, we were told that there was not an ability to have translation. They didn't have the room for it. They didn't have the setup. And my father fought tooth and nail for us to get translation. It did mean that we had to move to a different prison in order to get the translation booth and the translators in there. But his original trial was in English. But I know he's French, that's his right. But it's also the right of the victims. We're the ones that are suffering. He's put himself in that position, but we as victims deserve to hear everything and understand everything. So we did accomplish that, but it wasn't easy.
Okay. Donc, c'est la...
So it was his parole hearing procedure that he requested that it happen in French. Is that right? The trial initially was in English, but the parole hearing happened in French. Is that right?
Yes.
Okay. Merci.
Okay, thank you. So I think that's a question that we should come back to for our report. I think it's important. I thank you for having brought it to our attention, this issue. On the other question, with respect to restitution, or if there's if there's choices that are made by the accused for the hearing, or were you contacted in any way by the prosecutor, or you had no contact, and then you heard on the morning of the hearing that it had been canceled and the date was changed? Is that right?
I flew up there. My parents drove. They were probably in their early 60s, so they drove from New Brunswick to Montreal. And as soon as they pulled up to the hotel, they had a phone call saying that the hearing was canceled. And that we weren't given another date for I don't know how long.
Mais cette remise-là...
So that cancellation was the day before. I understand that your parents were arriving at the hotel, but was it the day before, or when exactly?
It was the afternoon before the hearing.
Okay. Et est-ce que ça s'est...
Okay. And did that happen more than once, or was that the only time that that things were rescheduled at the last minute?
I believe he's canceled a couple more, but they weren't ones where we were to attend. They were reviews that they just did there, and he had canceled some. And we come to find out later he's canceled them because he's done something wrong. And he doesn't want to go in there and have them say right off, no, you don't get it, go back.
Ouais, les raisons étaient
So whether the reasons were relevant, that's one other thing. But I don't think it's acceptable that you're only warned the day before, especially when you come so far to have to go to Montreal and have it canceled. So the Crown prosecutor didn't tell you to. Would you be agreeable to some reschedule? Everything was done without you had any type of consultation, or you weren't informed beforehand at all.
No, we had no information before, no warning. We thought the hearing should have gone on regardless. If he did something wrong, it should have come out so that we are all aware of what happened. And we weren't told, we were just told that they had to send him back to medium security prison.
Thank you, Ms. Davis. Thank you, Monsieur Fortin.
Merci, Davis.
Next, we'll go to a 6-minute round with Mr. Garrison.
Thank you very much, Mr. Chair. And I want to start by thanking Ms. Davis for being with us today. I know, even though many years has passed, that it must not be any less difficult to come and relive the loss of your family, and your dedication to public safety and to making sure there are no other victims of this offender is admirable. Despite the difficulties of the system, you have persevered, and I think we all thank you for that. I know it was a long time ago, but can you talk a little bit about how you became aware of your rights as a victim of this crime? So was this all through your own research, or was there any outreach to you at the beginning?
During the trial, we did have a victim service person with us, but after the trial, that was it. It was gone. No one told us anything. I had moved to the Yukon, and I decided up there I was going to try and see what I could do, what I could find out. But it wasn't given to me. I searched and searched for it until I found that I could get information on him, that it was my right to get information. So I got that. I passed that information on to my family. And we went on from there, just trying to do our best to find ways to get information to what's going to happen, what's coming next, how long till this is going to happen. But nobody reached out to us at all to tell us where we should go when it's getting closer to his parole dates. No one reached out and said, so, it's coming up in another year or two, he'll be due for parole. We just want to get you ready for it. No, there was nothing like that.
So we've heard testimony from other victims and victims' rights groups that there should be some kind of both initial compulsory notification of victims and that there should be ongoing compulsory notification of victims. So I'm assuming that you would be in support of those kind of provisions.
Absolutely, yes.
And I think your point of transparency is an important one. It's not only does there need to be information about the process, but the content of the process is quite often kept hidden from victims. So I guess I'm asking a leading question again here, but not just notification of the process, but the content of what's going to be happening in the process would be important to victims.
It would be, and it would be good for us as victims to know what's gone on since the previous parole hearing. Has he made any changes? Has his behavior gotten any better? Is he going to start to show remorse? Has he done anything to better himself? And we don't find out any of that until the parole hearing. That's all kept away from us. All we get is updates on his parole, like his day parole, or if he has to go to a doctor's appointment out of the area and stuff like that. But when it comes down to stuff that really matters, that we need to know in order to help talk to the parole board and let them know how we feel and what we think, we don't have that information. We don't have his convictions or anything he's done until afterwards. Like, we found out he was gambling, and then he was selling cigarettes, and then he got himself into debts, and then he couldn't afford this and that. And he gets to those places, and that's when you start to commit crimes again, because that's all you know. But they don't tell us any of that.
So when you're trying to prepare victims' impact statements, you're actually doing it in the dark, essentially.
We're doing it from the last parole hearing and kind of what the decision was then. That's basically all we have to base our statements on, which isn't much. Like, we go back to when it happened, because that is still, it's very fresh in your mind, and you relive it every time you go to a parole hearing.
And I just want to return to the question that Mr. Vertan was asking about on language. Has the situation improved on language since your previous experiences, or are the proceedings, have they been going on in English so that this became not an issue again?
They remain in French, but we have been able to continue with the translation services. My father worked with the Victims Ombudsman for a while, and he was on a committee for victim services. So I think a lot of that is due to my dad's insistence and fight for victims, which I appreciate greatly, because none of us are French. So we really need to know what's going on in these hearings.
But it wasn't really offered as a matter of right. It was something, you had to fight for.
Yes, it wasn't offered at all. It was just said the hearing's going to be in French, so you can read your statements in English, but the whole hearing's going to be in French. And my father just said that it can't happen. It's not fair to the victims. We need to know. We're given the right as a victim to go to these hearings and present a statement, but we should also be able to learn what's been going on and be able to hear and understand what the parole board is saying, what he is saying, what his parole officer is saying. So it really is, and I don't know, I mean, there's other languages in Canada. I don't know if those are offered as translation when it comes to parole hearings, but I know French and English is.
Thank you, Mr. Garrison. And next to Mr. Richards for 5 minutes.
Well, first of all, thank you very much for being here today. I know this cannot be easy for you, much like everything you have to do in participating in the parole processes and various other things, I'm sure are incredibly traumatic. And so I thank you for being willing to step forward and put yourself through this difficult situation, because I'm sure it will help ensure others, a little less pain in other victims' families' lives, I hope. There's a few things that really hit me in terms of things you were talking about. The first one certainly is, the whole parole process. And you can correct me if I'm wrong in how I understood this timeline essentially to have worked, but this offender was in prison for a previous crime, was paroled, reoffended, has been sounds like in a lot of trouble in prison at various times. You talked about several hearings being canceled as a result of the offender being in trouble. So clearly not on his best behavior by any means in prison as it is, and then yet still somehow managed to get put on day parole, and then was able to essentially escape as a result of that and be out on, and when you look at that, and anyone who looks at that and hears that timeline, the outcome there is almost entirely predictable. It's predictable to you as a victim, as a family member. It's predictable to me hearing it for the very first time. How could it not have been predictable to our parole board? So there's clearly a problem there. There's clearly something wrong with that system. I wonder if you could give us, shed any light on potential ways that could be fixed. What could be done to ensure that those kind of mistakes aren't being made again?
I think their background really needs to be looked at. if they keep on having their paroles revoked, if they keep on committing crimes while on parole, keeping on committing crimes while they're in prison, I mean, that's obvious that they haven't changed. They're not changing. They don't deserve parole. You can only give someone so many chances. And for someone who's been in and out of prison since 1970, as this offender was, I don't think you can rehabilitate him. I think he chooses crime, and that's his choice. And we as victims and the public shouldn't have to suffer for it. And I think the parole board just kind of looks at it as, well, you know, they've been in there for this long. We have to continue giving them parole hearings. But even in this case, there's not going to be a parole hearing, even though he just escaped and he was gone for 3 weeks. No one knew where he was. For 3 weeks, he escaped custody. And we don't even know what the warrant was for. We don't know what he did wrong. So it just makes it's difficult to know that this decision is going to be made without any input from the victims.
Yeah, there's clearly a problem there, and clearly there needs to be something learned from far too many examples of what your family has gone through and what, unfortunately, many families go through as a result of a failed system, frankly, that allows offenders to continue reoffending. There's a real problem there. So thank you for those suggestions. You mentioned about the translation. I mean, I think there's an obvious solution there. If a victim needs translation into their language, it should be offered without a victim having to fight for it. That one, I'm sure you would agree with that. Now, the other thing I wanted to touch on, if we can, is you mentioned, and I want to commend you for taking action where the system itself didn't, to ensure that the public was informed and protected from someone who's clearly a danger to society. And I commend you for doing that. And it sounds like it may have resulted or potentially at least aided in him being essentially caught, which is good. But obviously we shouldn't be in a situation where victim's family has to take that kind of action. So clearly there's something that needs to change here as well. Can you give us any suggestions or recommendations on what could be improved to enable the system to ensure that victims don't have to be the ones taking action, that the system itself actually takes action to protect Canadians?
Sorry, Mr. Richards, unfortunately time's up, but I'll
Well,
maybe flush it
if
up.
I can, Mr. Chair, if I would just ask Ms. Davis, then if you have suggestions on that, please provide them to this committee in writing, because I think it's very important that any suggestions you have be considered by this committee. So since you're not being given the time, maybe you could send it in writing and we can make sure that they're followed up on.
Absolutely.
Thank you.
Thank you very much.
Ms. Briard for 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you, Madame Davis, for your testimony. And we can tell that this is very difficult. Since the adoption of the Charter of Victims' Rights, have you seen any type of positive evolution since that charter was adopted? And what would you make as recommendations?
All the parole hearings I've gone to, they have all seemed the same to me. I haven't noticed anything's changed. We're not, I can't say we're offered support when we're there. We're not when we go for our hearings. And we're especially not provided information. So there's barely any transparency about what goes on outside of the parole hearings. We really don't know anything. All we're told is, well, they're on work release or they have to leave the area to do something. Other than that, we know nothing. until we go to a parole hearing. So I think that we should, as victims, be able to know more of what he does day to day, and if he's doing anything wrong, if they're thinking about revoking his parole. We should be told that stuff. That stuff we as victims deserve to know. The only thing I've noticed that has gotten better was the ability to get the translation. And I wonder if there's victims out there that can't attend hearings because maybe they can't afford to go to them. Like, I know your travel and your meals and whatnot are paid for, but especially in this day, people can't afford to take that time off work to travel. That's 3 days. So how many people how many victims are not able to speak up and fight to make sure justice is served? And I think victims deserve that. They deserve some type of compensation to be able to go aside from their travel. People just can't afford to lose 3 days' wages to go and fight for something that's their right to do.
Merci. Merci beaucoup.
Thank you. Thank you very much. Do you think, earlier we heard organizations that work to protect the rights of victims, do the victims and their families, as far as you know, are they aware of these organizations, that they can access help, that it's available? And if not, when do you think victims need to be informed that this services exist and that they can have recourse with them?
It would be nice through our victim services, through corrections, if they could compile a list of organizations that are there for the victims. We don't know any of them. We've never been given like a list, like you can go here if you need help, or if you need to talk, or if you're looking for information. I don't know what's out there personally. I have no idea because no one's ever told us.
Merci.
Thank you. You spoke about the question of translation, that it wasn't possible and that your father had to fight in order to get it. So that is a barrier to access justice. So for you, what do you see as other barriers that exist and which makes access to the justice system difficult? How could we improve the navigating of the justice system for victims?
Okay, well, for one, we're not given a whole lot of notice before a parole hearing. 3 weeks to a month is what we're given, which can make it hard. Some people just can't change their schedule all up, so they don't end up going. And I don't think that's fair, because a victim should be there. They should be there to fight for justice, to show that they're there, they're strong, they want to fight. But it's only short notice. Some people just can't arrange their schedule to get to these hearings.
Thank you. Thank you, Madam Briere. Thank you, Ms. Davis. Last round, we'll go to Ms. Monsieur Riel for 2.5 minutes.
Merci, Monsieur.
Thank you, Mr. Chair. Madame Davis, it's interesting, but unfortunately deplorable. And the question of translation, I think that's very important, and also rescheduling that's unannounced, and also conditions that could mean that parole would be revoked. So whatever the time period, if it's every 2 years or every 5 years. But what I would like to ask you about is the participation. I understand that there is, of course, inconveniences if there's last-minute rescheduling, but over the pandemic, we worked virtually as right now, I'm in my riding office, and I'm able to participate virtually with the committee meetings, and I do have translation services. Even if I'm asking my question in French, it's being translated into English, and you can answer. And your answers are translated into French, and I would like to thank very much the interpreters for their services. But if the tools for parole, the whole parole process, would allow for both in-person hearings, but also that virtually victims could participate in hearings. Would that be satisfying or not?
Yes, we tried to get that for the last hearing, and we were told they couldn't do video for us. The offender and the parole board had video, which I assume was maybe like this, like Zoom, but it wasn't offered to us. We weren't happy about it. We were on a phone for hours and hours, but for victims, it helps to be there in person and actually see what's going on.
Il me reste quelques secondes.
Just a few seconds. Were you told why it wasn't possible?
They just said they didn't have the equipment to do it. They just couldn't do it.
Mais il l'avait pour l'accusé.
But they had it for the accused and for the parole hearing, so why not the victim? What type of explanation was given to you, after all?
I don't believe, aside from just saying they didn't have the ability to do it for that, which I don't agree with, because Zoom was in place at that time, because we were using it for school.
Thank
Merci,
you.
Madame Davis. Merci, Monsieur le Président.
Thank you, Monsieur.
Thank you, Mr. Chair.
Ms. Davis and Monsieur, but Mr. Randall has passed over his time in light of the schedule right now. So I just want to thank Ms. Davis, who's been really advocating for this for so long for your family. It must be very challenging to go over this over and over again, but we commend you to give us insight into this. I want to thank all the members. Just before we go, I just want to let you know that for next meeting on Thursday from 3:30 to 4:30 in the first round, we have 5 witnesses, but the second hour, we're still waiting for Calgary Legal Guidance, Criminal Lawyers Association, and the Ottawa Coalition to End Violence Against Women, and Dr. Loana Heidinger. So if that's your witnesses, maybe just push them to see if they can attend. Otherwise, the meeting's adjourned. See you Thursday.
Thank you.